There you go.
You spoken to him?
I spoke to Mr. Keith, yes, Your Honor. He's up in Clinton County Jail. Hearing by Zoom. Just happy to see him.
That's done me like 3 times. So
All right, this is docket 22. I'm sorry. Yeah, I'll go on the record and we'll, that's subject to me. Oh, there is subject.
That's not Mr. Keith.
Oh, is that not him?
No.
oh, hang on.
Surprise.
You might still be in the breakout room then. Yep, I got him.
Thank you.
Income. All right, there's no video. That's not too bad. All right, we're good.
All right, this is docket 22260FH, Equal State of Michigan versus Russell Dwayne Keith Jr. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Jacob Sarge, the fourth Assistant Public Defender, appearing on behalf of Mr. Keith Jr. He's appearing by Zoom this afternoon from the Clinton County Jail.
Thank you. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
You may put your hand down. Sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
You had enough time to speak with your attorney?
Yes.
All right, sir. This is a bench warrant arraignment. I have a bench warrant that states that you failed to make reports to a court agency as specified by this court or the agency. And what is that, pretrial services? Is that what it is?
That's correct, Your Honor. Those are the
Okay.
allegations.
I don't know why they said a court agency, it'd be pretrial services, so I'm gonna amend it to pretrial services. How much more vague can they get aside from leaving it blank? Court agency could be anything. All right, so sir, you failed to make reports to pretrial services as ordered by this court. And you are on bond conditions for count 1, assault with intent to great bodily harm, less than murder by strangulation, 10-year felony, count 2, interfering with electronic communications, 2-year felony, assault or assault and battery, 93-day misdemeanor. Those are the allegations against you. Sir, do you understand what I just said?
Yes.
Counsel, you're waiting for the arraignment.
We do, Your Honor. Thank you.
And how are we proceeding on this?
Your Honor, I'll defer to Mr. Keith, but it's my understanding he is willing to admit that he failed to report to pretrial services.
All right, and this is a 22 file. Has he been gone for that long? Have we had a pretrial on this?
Your Honor, if memory serves, he failed to report to pretrial services. Your Honor issued a bench warrant for him. He failed to report for his pretrial as well, which was set for early August. So no, I do not believe we had a pretrial before, Your Honor. Mr. Keith is currently up in Clinton County Jail. He's serving a sentence, and he will remain in Clinton County Jail at least through November.
Okay, thank you for that update, because I'm looking at my file, it looks like there may have been a pretrial, because there's a pretrial statement, but that was August 2nd of 2022. Elizabeth Allen at that point was my prosecuting attorney. And he was in custody at that time, and it looks like I don't have really any contact after that. So, thank you. On behalf of the people, any update?
And that is my understanding as well, Your Honor. It looks as though, looking at the notes, I believe he was actually in jail, so he was not even present for the pretrial at that point. So it has been about 4 years. I have not had a chance to talk to Attorney Starks on this case yet. I will say that the offer that was conveyed at that time would be the same offer that we are offering at this point, would be a plea to an attempt assault to do great bodily harm less than murders to the 5-year felony, and then an added count 4 of domestic violence. And we would dismiss count 2, the interfering, count 1, the assault proper, and count 3, the assault battery in its entirety.
I'm sorry, so the attempt, the 5-year would be count
It would be, sorry, that would be added count 4,
4, and the other
and
one
the
count,
DV would be added count 5.
and then 1 to 3 would be dismissed.
Correct.
All right, any sentencing recommendation?
Not at this time. I haven't had a chance to run the gut. Actually,
And I don't know what his history here, I don't know how old he is he eligible for HYTA or anything else?
he would not be, Your Honor.
Okay.
Well,
Well,
I think he would be if we consented. Based off of what I have, because of the age of this offense. I do believe that we would have to consent if he were to get HYTA.
Is that both are accurate and complete?
that's understood, Your Honor. Negotiations will continue. It is fair to say that he would be potentially eligible for HIDA with the people's consent, because the allegations here go back to 1/21/2022.
And
So
how old is he then, do you know?
well, he's currently 28, Your Honor.
Okay, all right, thank you. So, sir, is it your intention to plead to the allegation against you in regard to the bond violation?
Yes.
And then we'll continue, we'll set a final pretrial in this matter, and you've also heard what the offer is in regard to the potential plea. You don't have to take it, just making sure you heard that.
So, it's just admitting guilt, right?
The only issue we're going to handle right now, Mr. Keith, is this bond violation. You have the option to plead not guilty, and we could set this for a hearing, or as we discussed, the allegations that you had failed to report to pretrial services back in the summer 2022. You have the option to plead guilty to that allegation as well. If you choose to do that, then I'll ask Judge Aquilina to proceed with immediate sentencing so we can get this warrant cleared up for you.
All right, I will do that. I will plead guilty to the bond violation.
Okay, so you understand you understand what it is, failure to make report or failure to report to pretrial services, and that would be since on or about November 29th, 2022.
Yes.
Okay. And are you going to be pleading of your own free will?
Yes.
Meaning no enforced threat or coercion to plead?
Yes.
You're deciding to do this after you spoke with your attorney?
Correct.
And you've been satisfied with the representation of your attorney?
Yes.
All right, sir. As to failure to make reports to pretrial services or report to pretrial services since on or about November 29th, 2022, how do you plead?
Guilty.
And sir, you knew when you were placed on bond conditions that you needed to regularly report to pretrial services as often as they wanted, whether it was in person, telephone, or otherwise. You understand that? You did understand that at the time.
Yes.
And you failed to report as directed, correct?
Correct.
All right. And based on that, I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made. And that based on his acknowledgement, he understood and then did not appear. I find there sufficient grounds, therefore the violation of bond conditions will enter. Maybe go into immediate sentencing on behalf of your client.
Yes, please, Your Honor.
Yes, Your Honor.
All right, and what is the recommendation or request from probation?
Your Honor, I do not have a probation officer.
Or I'm sorry, or pretrial, or on behalf of the people, I should have said, there's no probation at this point.
Yes, I will say, Your Honor, I would agree with Attorney Sarks that he is currently serving out his jail sentence in Clinton County. It looks like he was sentenced on June 3rd, and he was sentenced to a resisting and obstructing and a fleeing fourth to county jail, not less than 365 days. So at this point in time, I do believe it'd be appropriate to, I'll leave it in the court's discretion.
All right, thank you, counsel.
Thank you, Your Honor. Respectfully, Mr. Keith has learned his lesson that he needs to report to pretrial services. He does have a lengthy bit of additional time that he needs to serve up in Clinton County. Respectfully, I request that he be given credit for the time that he served and that he be granted a cash or surety bond. He's not in a position, he would not be able to post that cash or surety bond, but in the event that in the future, once he serves his time, if he's granted a cash or surety bond at this point, Your Honor, he might have an opportunity to potentially be released. So, Your Honor, at this point, respectfully, I request just credit for time served essentially for the bond violation. And I request a cash or surety bond, a low cash or surety bond in his behalf.
Is he entitled to credit on our file?
I would ask for 1 day credit, 1 day served, Your Honor, something to that effect. No, he would not be entitled to credit. He's serving a sentence for his case of a Clinton County.
Sir, what would you like me to know?
Nothing.
All right, I am not going to step on. I need him to be transferred from Clinton County to us, and then I certainly will entertain a bond motion when I have verification of where he can live or what he's doing. He's been gone. He ignored this court for 4 years. I have no idea why I should give him any credit or deference when he's ignored this court and now is sitting in another county's jail. I'm gonna give him 93 days. I don't think he's entitled to any credit. If he is, we'll give him the credit. It's 93 days contempt. And whether or not I apply that to this, I don't know. But we are going to set is it a final pretrial? Is it, or we had a pretrial, we should set a final pretrial.
I would agree, Your Honor. I would say sometime within the next, at least the next month, just so we can get this taken care of as soon as we can.
Okay,
I'm fine with that, Your Honor.
If
Yeah,
you
we can
have
set it
what
for
you
final
need.
pretrial and trial date.
thank
That's
you.
fine.
You have what you need, sir, to have a meaningful discussion in regard to the issues that are pending?
I do, Your Honor. I will follow up with Mr. Buxton with additional negotiations before the final pretrial date. In the meantime, I will need to make sure that we have writs out for Mr. Keith. Thank you.
All right. So we're gonna have a final pretrial August 26th at 1 o'clock.
Thank you, Your Honor.
Thank you. And then if we need to move that, you certainly can. It's not going anywhere for a while, but August 26th at 1, it won't take more than a few minutes, depending what he wants to do. If there's not enough time that day for a plea, if that's what he wants to do, we can set it within a couple weeks of that. But let's keep this case moving. It's an ancient case.
I agree, Your Honor.
Understood, Your Honor. Thank you.
Thank you.
Thank you.
Thank you. And as to the 93 days contempt, that will run concurrent with what he's doing now, so get double credit. I'm gonna work with that, counsel.
Thank you, Your Honor.
All right.
Appreciate it. Thank you.
Sir, you got a lot of hard work to do. Don't make things worse on yourself and talk to your attorney, okay?
Okay. Thank
All
you.
right, whatever. Are you doing some services in that jail?
I'm doing I did clean slate program. I do AA every Wednesday. I go to church twice a week. I'm currently attending my GED. So
Great. Great, that will help you in front of me, so keep up the good work, don't get in any trouble, let's figure things out, okay? Talk to your attorney. All right, thank you, that's all for the record.
Thank you.
Thank you.
Do we have, the individuals for Brandon Knott? I know the AG is here, but I'm not sure if Sato or if the individual that's on Zoom right now is Mr.
No,
Knott.
we got an email about that one this morning. Let me look real quick. MDOC could not have Mr. Knott appear today, so it needs to be adjourned to a new date. It doesn't look like you were on that one. It looks like Libby had gotten put on that.
Okay. Which one is that?
Brandon Knott.
That's mine. It was his motion to allow contact with the children from prison, because you had put a no contact in place.
What's your email? I'll forward it to you.
It's Brenner, BRENNER.
Yes.
At Michigan?
Yeah.
Okay, I got it. Make sure you're included.
What was that, Jen?
Oh, I'm just gonna make sure we get a copy of that in the file too. I don't know.
So you're just gonna send it to me?
Yeah, we'll get it.
Okay. What else do we have?
I think we'll do Carter Van Steel next, Your Honor.
There's really no quiet way to do that.
What's the correction one? Do you have the correction one?
Yeah, they've already sent to Hopkins. No, we just gotta bring it down when she comes down.
Okay, great. That's off. Do you know that? Nancy? Hopkins is off. They stipulated to correct it. I don't know whatever, but they stipulated, so that's off. That's off. This is docket 256807FH, people of the state of Michigan versus Carter Van Steel. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Van Steel. Mr. Van Steel's present, stands to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. You put your hand down. Have you taken any medication yesterday or today? I can't hear you. What? Okay, and so I don't need to know what, but that's fine. Is that anything that would interfere in your ability to understand the court or your attorney? You're able to understand everything?
Yes.
And is there medication you're supposed to be on that you're not on?
I'll forward it to her. No.
Any sign of fever, COVID, or other illness? And have you had enough time to speak with your attorney?
Yes.
And this is a motion hearing.
That is correct, Your Honor.
We proceed.
Thank you. As
It is outlined in the motion that we did file. Basically, what's going on here is that we want an adjustment to the bond. The pretrial services did make their recommendation, however, the request from the defense is to just modify the bond to allow release to treatment, whether that be mental health or a dual diagnosis, whether that be someplace like Fair River for drug treatment as well. Mr. Van Steel has completed, he was serving a jail term for a sentence out of the 54A district court. He has completed that. And at this time, we would ask this court to allow him the opportunity to be released, PR bonded, as soon as there's a place available for him for drug treatment. He has been working with Pathways to Care. I do have the release that he's put forward. The issue that keeps coming back from the jail is similar to the previous issue that I was talking to the court about, but we're pre-plea at this point on Mr. Carter and Mr. Van Steel, is that they cannot release without a PR bond or a PR to treatment. So we'd be asking the court to adjust that as well as to set this for a new pretrial date.
Do we need a forensic hearing at all? Or
At this time, I don't think so, Your Honor. I have been able to have, and so has my social worker, communication with Mr. Van Steel. I think a lot of, sometimes this has to do with, I think DEPA code sometimes can cause lack of a delayed response, but he is able to have conversation with myself and my social worker, as well as CATS and the Pathways folks. But I do understand, and it is something I've been keeping on my radar. I understand the court's question. At this time, he appears to me to be competent. He just,
so in terms of helping you, I mean, there's a delay. I figured that was the medication, but what about at the time of the offense? Do we need to send him to forensics for responsibility or not? Wasn't medicated at the time. I'm seeing the delay. He's on medication now. I don't know if he was on medication or needed to be on medication at the time of the allegations against him. So do we need, before we get to releasing today, do we need to send him to forensics for that determination? I don't know the case. You know the case. It's just my responsibility to ask you all, because I don't want it to come back that we should have and
I
didn't.
understand. That is something that I've been in discussion with. However, it's not, I'm more concerned with trying to get him out for treatment at this time as opposed to.
Well, they would treat him there as well, but I just, is that an issue? Can we take care of two things at one time? Or I just don't want this to be delayed and then someone says, oh yeah, he should have gone to forensics. Now there's a criminal responsibility issue because he wasn't medicated at the time, or was over medicated, or whatever the argument is.
May I have a moment here?
You may. Let's go off the record.
Think we probably should. I believe at this time, and I do believe that that is an evaluation that can be done remotely as long as it's a secured location. So I don't believe that that would hold up treatment.
Okay, so let's go back on the record. So you have indicated that it wouldn't hold up treatment or the court because it could be done remotely. I think, sir, it's in your best interest to have that done because these are very serious allegations against you. But if you were not medicated, you may very well have a defense in terms of criminal responsibility that you didn't understand what was happening at the time or what you were doing. So it's really in your best interest. It's some extra testing, but it sounds like maybe you need, or we need to explore that to make sure we're not trampling on your rights if there was some kind of medical event. Does that make sense to you?
Diagnosis is a good idea.
Okay, good. So I will sign the paperwork. We can get you the form today, and I take it that people have no objection to that, or to his going to treatment.
The only thing, Your Honor, is I did have a chance to talk to the alleged victim in this case, Alexis Smith. Just so the court is aware, she did not know Mr. Van Steel prior to this incident. She was just a employee at a grocery store when this incident allegedly happened. When I talked to her about this bond, the bond hearing, she was very terrified about him potentially being released, and I want to say she almost had a panic attack with me on the phone, to be quite honest.
I'm sure.
So if you
There'll
were
be a
to,
jail GPS cover.
and that's what I would be
Yes.
requesting, Your Honor.
Yeah, of course, any of these, that's what I do, so I certainly understand that. But thank you for making the effort. What was that business that she worked for? You know?
Let me get the exact address, Your Honor, one moment.
Hmm? Yep, you don't go there, that's right.
Your Honor, this was at the Meyer that was located at 600 East Michigan Avenue in Lansing.
Is that 600?
600 East Michigan.
Okay. So are we sending him for substance use? Where are we sending him?
Substance abuse, I believe, I would be asking for wherever facility is available first, as he has been in custody for some time now. I'd like to.
I want the most effective. I don't care about whether he's in custody or not.
I understand, Your Honor. My thought would be Bear River, because they are dual diagnosis.
Okay.
Your Honor, I'm also seeing in his criminal history, he had pled guilty to an operating while intoxicated, so I'm not sure if alcohol may be a potential issue for him as well.
So is that, what's your substance abuse history? Is it alcohol, use of something else?
Cannabis.
So marijuana and alcohol? Anything else?
Vote over for cannabis.
Your Honor, good. Pathways to care, is that accurate? Your Honor, that it appears he also may have some concerns in the past anyway with methamphetamine. If you have a chance to talk, what do you want to say? Your Honor, could the prosecutor and I approach?
Yes.
Thank you.
All right, here's what we're going to do. I'm going to give you a $50,000 PR bond upon acceptance into the forensic center. and or long-term residential treatment for mental health, substance abuse treatment, dual diagnosis, treatment facility for meth, alcohol, marijuana. It does appear that you need some help, sir, and sometimes people get into trouble. Sir, do you look at me?
Yes.
Sometimes people get into trouble because they have some kind of mental issue that they can't get over. And then when you use illegal drugs, it makes it worse, not better. And I suspect you were self-medicating because you had a diagnosis that was not diagnosed yet. And so we're going to send you to the Center for Forensic Psychology for criminal responsibility and competency. And then from there, I don't care how they do it, the jail will work it out. You could either go to the forensic center first, or you can go to another treatment facility. And then the forensic center, if they can do this remotely, I really don't know, but we're gonna try to put you in a better place than the jail, so you get some treatment and you get the evaluation for criminal responsibility and competency, and see if you're even on the right medicine. I don't know at this point. I suspect whatever doctor gave you that medicine is good, but I also understand that the jail has some limitations on the kind of medication they can prescribe to you. So there might be something better that the forensic center gives to you that might help you without this sort of delayed response in your head, because I can see there's some issues there. I don't know if this is the right medicine for you. I'm not a doctor though, so I'm seeing the result of it, and it is quite concerning to me. So however the jail wants to do it, I've written up this bond, and then of course, once you're released, it'll be with the jail GPS, because you should come back to this court. And I need verification of your address and all of that, so you will not be within 1,000 feet of Alexis Smith. There'll be no contact order, which means you don't contact her in any way, shape, or form, personally, through a third party. If she comes within your view, accidentally, somehow, if you're in our community, you just do about face and leave. You'll not be within 1,000 feet of her work, school, home, or the Myers located at 600 East Michigan Avenue. Is that acceptable on behalf of the people? Is there anything else?
No, Your Honor, I think that satisfies the people. Thank you.
And you need to follow all doctor's recommendations, take any psychotropic medication as prescribed, and show prescriptions for medication from a licensed medical physician for pretrial services within 24 hours. Is there anything else? And then I'm going to have him returned to the jail. After treatment. Unless counsel you petition this court, there's an agreement to go to some kind of verified address where he's taking his medication, monitored and all of that.
Yes, sir.
I don't think it's fruitful for us to do all this and then release him to an address that might not be verified or he's not getting help, because I suspect he's going to have to, we'll make that decision when he comes in front of me after I get the reports. It is very bottom line, but I don't want him accidentally released, because then we're doing him a huge disservice as well as the public.
The only other thing, Your Honor, is that we have a final pretrial set for this month on the 29th at 9.
Not anymore.
Correct. I just want to make sure we have a status conference date so we can keep an eye on the competency.
So let's do a, I'm gonna do a status conference / pre, well, we can decide on other dates. Let's do a status conference. That's probably 90 days. So
Sometime in October, Your Honor?
I'm thinking maybe November, because they're always behind our work. So let's do status conference,
Yes.
November 18th.
What was that date, Your Honor? I apologize.
November 18th at 11.
November 18th at 11 a.m. Got it. Thank you.
hopefully you don't have to read this, so we'll get that. And then, sir, you just need to cooperate with everyone and take your meds, tell them how you're feeling. You need to sign releases. Do you have a psychiatric history when you were a little kid? Did you see any doctors? Okay, so doctor, he's a good doctor, Ratio, so if you could sign releases, maybe counsel your office could help with that, sending that over to Dr. Ratio, so he can send over to the Forensic Center and any other doctors, he can probably have a full history. So, and I don't know, did he prescribe any medication or did somebody else when you were?
It appears from the releases we have, he has been medication compliant in the jail. He is taking medication in there.
I just don't know if this is the right one. Given what we see here.
Given what I've heard in confidence here, I would say no.
Yes, so sir, we just need to, I hate to make this longer for you, but we just need to make sure all your issues are handled so you're safe and you get back on the road to recovery in a good way with proper medication and treatment. And sometimes it's not able to happen in jail because they have their rules about treatment, about medications that they allow. So this is really to serve you, okay? And then if you have a problem, or you don't like where they place you, or you think it's taking too long, or whatever your issue is, reach out to your attorney. Do you know how to reach her?
You've spoken to my, sorry, if I may, Your Honor?
I'll talk to the case manager about contact.
Yes. And then my social worker, Sophia, still is coming to see you, so you can always let her know too if you need to get a hold of me, okay? Thank you.
Okay, so if there's anything that else that arises, I need to amend yours, please let me know, or your social worker can reach out to me and the prosecutor, however you want to do that.
Yeah, sure.
Really concerned about his appearance today.
Yeah, sure.
Okay, sir? Do you have any questions?
There's something wrong with the jelly in the breakfast. So if they had a jelly which was like spray on instead.
Do they have a spray on jelly? I don't know that they do. Do they give you little containers of jelly?
So the jelly, when they use the jelly, it's like there's something wrong with it.
They don't run the jail, but I bet if you talk to somebody over there about the food, if you have a special requirement, they'll help you out. Okay, and if not, I'm sure your attorney or social worker can do that for you.
Is it possible to get like an extra helping today or tomorrow?
Have you not been eating right, or you just?
I've been too malnourished. I have a super high metabolism. I have an extra.
Oh, super heavy. Sure, we'll put on the court note to give you an extra meal because your metabolism and the medicine you're on, I suspect that has to do with how hungry you are, and you are very thin.
I
so-
suspect that's what,
I suspect that's why you are so thin and hungry, because your appetite is being affected by the medicine. So we'll see if we can get you an extra sandwich or an extra meal. We'll put that on the court note to the jail, okay? If that doesn't happen, let your attorney know, and we'll also make that note to the forensic center if you're sent there, or whatever other treatment facility, and they're usually good at that. Okay, so you just gotta speak up and let people know, okay? Okay, so we're gonna hopefully have that happen, okay? Okay, that's all for the record.
When's the next day, Judge?
That was the,
November 18th and 11th.
Thank you.
We've been noted for Sophia to keep regularly seeing you while we're getting in place somewhere, okay?
Okay.
All right. Sure, thank you. Your Honor, do I need to submit that order for both of those evaluations?
yes.
I will take care of that.
We
Sure.
have those, we should have blank those.
Yes, I believe you do. Do you need a petition along with that, or would the orders be sufficient? Thank you.
Yeah, save your time and money, and me too.
Very good, Your Honor.
Those are the orders we've done on the record, so
Yes, thank you.
no problem. Next matter.
Judge, can I project some orders on some?
Yes,
Hearings
you're
we're gonna have?
resolving that.
Yes. There's 4 cases, but we resolved them, so there'll only be 2. When we get to them.
Cleveland.
Regina Black's.
Green. Yeah.
Yes, it is.
Hi, Diane.
Yeah.
We got good July
These
coming.
is gonna be all the same information.
You know, I gotta be there.
Yeah.
I'm not here. Hope this stuff here gets your sign in. Yeah. I appreciate it.
Just hold on to your home. I know. They're just, you know, use the house nice.
No, that's
and
okay.
I know.
Lower on market dishwasher.
I know.
Walk
I
out of
have
the
them
house
doing
on your
chores,
own.
but I'm like, how did you set all your stuff back? They just, I don't understand.
Yes.
And then cry. I wanted to leave so I can throw their stuff away without them seeing. You know, at this age, everything's important. Right? 3 different cases, yeah, but we just stipulated to. We're having a situation where you guys, things are corrected on the record, and for some reason, MDOC doesn't correct their PSIs to send to the prison. Someone told me there's like a stack they had down there, and the first time, they're like, we didn't know what to do with them. I'm like, you said MDOC. So these are just orders saying, we agreed. She said, of course I stipulate, they should have changed them and sent it. That's all it is.
Because I see that all the time on the attached forms or the.
Yeah.
Prior, and like,
Criminal.
says correcting, and I'm like, oh, what happens?
And yeah, they just sit downstairs. And that's not fair.
That's not.
We have to go through this process, and now the victims are all getting notifications, like, what is this? I'm like, it's just to have them send the proper report to the prison.
I mean, not the victims, but it's.
I know.
The prison knows that because they're always sending us crap letters.
Yeah, exactly. I think if they sit downstairs, the probation department, I don't know where the corrected one goes.
Yeah, because you just can't.
But it's like, what do we?
Blacksmith?
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
Yes.
Is it anything that would interfere with your ability to understand your attorney or the court?
I don't know.
Okay? Have you had an opportunity to speak with your attorney?
Yeah.
Have you understood everything?
No.
No? Counsel, is she supposed to be on medication? Sounds like there's some issues.
I was not made aware of any medications that she was supposed to be on. I know that there's been quite some time since she was last in front of the court. Maybe things have changed, but
Okay, so ma'am, what is the medication for? Can you tell me?
Mental health. Mental illness.
It's what?
Mental illness.
Mental illness? And what have you been diagnosed with?
Borderline personality, bipolar affective psychosis,
Okay,
major depression, generalized anxiety.
okay, and you, how long has it been
substance
since?
abuse disorder.
Okay, how long has it been since you were on your medication? A while?
The prescription, that never got filled, I got it. I hospitalized in Baltimore last Wednesday.
So you were just hospitalized, ma'am?
Yes,
Was it for the mental illness?
yes,
And you didn't fill the script?
no,
Okay. And is that because you can't afford it?
no,
Do you think you don't need the medicine?
yeah, I need my medicine.
Okay. I don't think we should proceed till she's on her medicine.
I would agree, Your Honor. I will note that back in April of this year, she was not present as she was in the psychiatric ward. So I know that she was in the psychiatric ward for a period of time. Obviously, I do not know what exact medication it is, but I would agree that she needs to be on whatever medication in order for us to proceed at this.
So can you tell me when she was in the psychiatric ward, was that when she failed to appear and we didn't know about it maybe?
No, Your Honor. Apparently, so essentially on April 9th, we were told that she was in the psychiatric ward and we adjourned the final pre-trial to May. Then on the May date, we had lost all contact with her, including her mom, and her mom had stated that she had just gotten out of the psychiatric ward in Grand Rapids.
So we don't know if she actually received notice of this, is that correct?
That's correct, Judge.
Okay, so I'm gonna withdraw this bench warrant because it says she failed to appear. And that would be for a pre-trial conference, May 4th, 2026. I'm gonna withdraw it at this time based on possible non-notice as well as just coming out of the psychiatric ward. I don't know how long she was on those meds. She's indicated today she needs to be on meds, and usually those meds, I'm not a doctor, but from what I know, having served for so many years and having these kinds of cases, it takes often 30 or more days for that to get properly in the system, and sometimes they have to adjust the medication, so it can take even longer. So at this point, I don't know, do we need to send her over to forensics?
Not at this point, Judge. No, she understands what's going on. As far as like the medication goes and things like that, I'm not sure if the jail is gonna be compliant with whatever she was released on. I know that there's certain medications that the jail just won't prescribe no matter what. So.
Taking my medication in jail.
What?
I've taken my medication in jail.
You are taking it now?
No, I have taken it in jail.
You have
I
pre-trial.
was in
Okay.
jail.
So I'm gonna schedule this in about a month, ma'am. Do you have a place to go? Do you have a residence?
She's being held on another charge, Your Honor, so that's down in 54A. So we would ask that Your Honor would set a reasonable cash surety bond so that she can earn credit on this while she waits for that case to come up here.
Okay, and who lives at the 210 West Jolly Road?
My mom,
And so when you're out of jail, do you reside with your mom? No? Where do you live?
I bounce around, I'm homeless.
You what?
I bounce around, I'm homeless.
You're homeless, so why can't you live with your mom?
Sometimes I can't, if I'm not on drugs, she'll let me stay with her.
Okay. So you've been using illegal drugs too? Yes, is that a yes? You're not,
Yes.
yes, okay, is that when you can't get proper medication?
Yeah.
Yeah, okay, so I need you to stay on your medication. I'm gonna give her.
What am I here for?
I'm gonna give you a $10,000 cash only bond. You're here for count 1, police officer assaulting, resisting, obstructing. Count 2, police officer assaulting, resisting, obstructing. Both of those are 2-year felonies. And then count 3, assault or assault and battery, which is a 93-day misdemeanor. And there are 2 counts of that. So, I don't know exactly what happened. I don't have a police report, but that's why you're here. And then you were brought before this court because you failed to appear. However, I don't know that you received notice of that pretrial. So what I'm going to do, ma'am, is give you a $10,000 cash only bond. I suspect you can't make that. And that will keep you in jail, and I'm going to tell you that you shall take all psychotropic medications. In jail, and the jail should let counsel, me and the prosecutor know if they can't comply, so we can then send her over to forensics to keep her stable.
I've been trying to get my notes since I got there. I've been talking to, medical about it.
Okay, well, now I'm gonna order it, so, I'm also gonna say jail to inform APA, PD, and judge if can't give prescribed meds, and then counsel get her in front of me immediately, so, or get me in order to transfer her over to forensics to keep her stable. We just can't have this, we're stepping on her rights if we keep her housed without doing that. Ma'am, we need to get you treated and get you housed and get appropriate services to you, so you need to work with us on that. So taking your medication is really, really important, so we can get you out of this situation, okay? I assume you want to be free and about your business, right? But you gotta take your medicine and you gotta work with us, okay? Can you do all that?
Thank you, I've been trying to get my medicine.
Okay. Well, if this ever happens again, you can send me a note. You can also, you have your attorney. The attorneys all have my personal phone number. We'll get it handled for you, okay? Okay, so. You know, I'm sorry?
Judge,
Okay, my law clerk will give you my card. I think they can have it, or can have that in the jail. Does she have your contact information? Or
She
you have to
does,
put it in the
and I'll make
record?
sure I give her my card as
She's
well.
lying. I don't have her contact information. I don't even
Okay,
know her
well,
name.
okay, she could, counsel,
She
just
told
write
me
it
that
in
I
the
was
back.
in possession. I don't want her as my lawyer.
I can grab
She
my
lied about what
card.
I'm here for. She's gonna be in possession. She doesn't even know what my case was for.
Okay, well, here's the thing, is when you could address that next time, and we'll see how you feel about it when you have your proper meds, and if, you know, we can always deal with that. But let me,
Do I have possession?
do you have
That's
possession?
my
of what?
charge.
Huh?
She said I have a possession charge. That's
You
my-
may have a possession charge in another county. What, does she have a possession charge?
I've never had a possession, not for drugs.
She doesn't have one open here in Ada County, no.
In another county?
I'm not sure about that.
Okay, well, right now, you just have the police officer assaulting, that's all I can deal with, ma'am.
I've never had a possession period.
Okay, that's fine.
And Your Honor, just so the court is aware, we did mention the other charges. Those charges are armed robbery and resisting and obstructing that happened back about around 4 days ago. That is set for a PCC in front of Judge Buchanan on July 23rd and an exam on July 30th.
Okay. For some reason, she is able to get the money, and I doubt it. She'll also have jail GPS tether. So I don't think she'll be able to get it. And actually, I'm gonna make that a $20,000 cash bond. I need her to stay in and get her meds, and then we'll get all these matters handled. And so then we could probably do one-stop shopping and put all these cases in front of you.
Thank you.
Okay, so we'll set this. I'm not gonna give you a date, so when your other case comes out, we're gonna do all the files at the same time. And my staff knows that, and counsel knows that, so we can look at this. And you need some time, yeah, your meds, so that you're very clear when you come in front of me and when you talk to your attorney, okay?
Thank you.
Okay. Anything else I can help you with, ma'am? Okay, you just gotta let us know what's going on, okay? Okay, we're gonna get you a copy of this.
Thank you, Judge.
Thank you. Good luck, ma'am. Okay, who's next?
Next is gonna be Jordan Cantu, Your Honor.
You know, that's some civil here, so are we almost done with just
one.
this one? All right. This is docket 252745 FH People of the State of Michigan versus Jordan Jeffrey Salvador Cantu. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Bucks on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Dwayne Sullivan from the Office of Public Defender on behalf of Jordan Cantu, who is standing to my right at the podium.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and nothing but perjury?
Yes, Your Honor.
Thank you. Put your hand up. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak to your attorney?
Yes, Your Honor.
Thank you. This is a final pretrial, as I understand it. Are there any matters we need to address before we address what the offer is?
A couple of things. I'm kind of new to the case. Jonathan Foreman is his attorney, but because of MIDC standards, although Mr. Foreman is a brilliant attorney and actually could handle it, he's not allowed to handle a CSE case, and he's had, and not he, Jordan has had, I'm about his third or fourth primary attorney, mainly with people, Mr. Milks and Ms. Lacey leaving our office. So that's kind of, I think, disrupted, it's no fault of Mr. Buxton, but it kind of disrupted negotiations a little. So we're coming into the final pretrial, but we haven't really gotten any kind of offer yet. And again, I think it's a little bit because of the disruption more from our office.
Let me just see, is there going to be an offer on this or not?
I've had conversations with the victim, so we are willing to give a plea at this point in time, but we need to have some plea negotiations. Unfortunately, because Attorney Silverthorne is new to this case / Attorney Foreman, I've not had an adequate chance to have real plea negotiations with them.
Is Mr. Foreman going to be second chair if we go to trial or what?
He will be second chair.
So you'll have some assistance if needed.
And I'll have assistance, and I'd also like to indicate that I had a pre-scheduled vacation beginning the Monday following the jury selection date. I understand that there's probably a homicide trial that's preempting it, but I would still feel more comfortable if that trial date could be moved out.
Which is when?
It's on August 21st, Your Honor.
Okay, well, the final pretrial is gonna be September 9th. You take your back vacation then,
Oh, yes.
and that final pretrial will be September 9th at 11 a.m.
Very good.
And then we will lose the trial accordingly, it'll probably be in 2027 because of the heavy docket. I suspect it won't be till February or March because we have a 5 defendant homicide that may take a month or longer, I don't know.
They can be very long, yes.
So we'll look for that date, but not today. Let's deal with the final pretrial, September 9th at 11 a.m. I take it you can make it. People have no problem with that.
That is fine with the people, Your Honor.
So bond conditions are continued. I don't think there's been any violations. I looked through the entire
He
file.
was just recently released.
Yeah, so it looks like everything's going well.
Right. And as a word of note, I would note that his father, his stepfather, and his mother have all appeared, and they accompany they've been here very, very long today. So that bodes well for various eyes that are important in looking at him.
All right, any problems with the bond conditions?
No, Your Honor.
All right, everything looks good. I'll see you September 9th at 11. If there's change, your attorney will be that.
Thank you.
Thank you.
Good luck
Ryan.
to you.
Good day.
That's all for the record. next matter?
Yes, Your Honor, we're gonna handle the appeals motions now.
Okay.
Judge, we do have some people on Zoom. I don't know, maybe it looks like there might be an MDOC.
Is there an MDOC? Do we have somebody from MDOC?
Yep, we have one at 2 o'clock and one at 3 o'clock.
We've got to handle the MDOC. They're gonna get us off.
Yeah.
But those are for you.
Yeah, that's me. That is me. I'm not sure, maybe I should unmute. Or Ms. Gittleman, do you recognize the site client?
Is that Cleveland Xavier?
Yes, Your Honor, that's the first one.
Okay.
That's the one that's happened. That must be-
This one?
Yeah.
All right. All right, this is docket 22839 FC, people of the state of Michigan versus Xavier Shamar Cleveland. Counsel, your appearances for the record.
Judge, if we could just confirm that's Mr. Cleveland on the hearing, I don't know if that is.
Sir, are you Mr. Cleveland?
He's muted.
You can't hear us, or we can't? He's muted, but-
He's muted, so.
The bottom right is waving and he's standing up, that might be him, 62007.
Yeah,
I don't see. Why don't I see that person in mine?
it's the bottom right corner, Judge.
Oh, this
Yes,
one.
you have to unmute him, just to confirm.
I've been hitting it twice. I've been asked to unmute, so we'll see.
Oh,
Here we go.
can y'all hear me?
Yeah,
All right, we good.
good. All right, thank you. So, counsel, your appearances for the record.
Elizabeth Allen on behalf of the people, Your Honor, good afternoon.
Good afternoon, Your Honor. Tracy Gittleman for Mr. Cleveland.
Thank you. Good afternoon, counsel. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
Yeah,
Is that a yes?
yes, Your Honor, my
Is
apologies.
it anything, just a minute, is it anything that would interfere in your ability to understand the court or your attorney?
No, Your Honor.
Is there medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you had an opportunity to talk with your attorney and to read the documents and all of that, and you're ready to proceed with this motion, and I don't know if you have anything to say in regard to the motion, but you are fully equipped to listen to the arguments of your attorney, is that correct?
Yes, ma'am.
All right, thank you. Then this is defendant's motion to withdraw his plea and begin the hearing. Counsel, you may proceed at the podium.
Thank you, Judge. Your Honor, I briefed the issues of Mr. Cleveland's relief he was requesting to withdraw his plea. I also filed a supplemental signed notarized affidavit as an offer of proof for Mr. Cleveland on his behalf as to why he is claiming ineffective assistance of counsel. I would refer, Your Honor, to, regarding the issues in this case, to the PSIR that does document that Mr. Cleveland, since age 11, has been diagnosed with attention deficit disorder, schizophrenia, depression, bipolar disorder, and PTSD. He was homeless at the time of all of this occurring, and all of that is documented in the PSIR. His claim is that twofold. Number one, he's claiming that he did not have the capacity when the crime was committed, and his attorney failed to investigate the defense of insanity, failed to ask for a forensic exam by the Department of Health and Human Services, so that at least there would be a report generated after an exam for the court to review, to have a hearing if necessary, and come to some conclusions about competency during the crime. Secondly, also to determine whether Mr. Cleveland was competent to take a plea voluntarily and knowing. Mr. Cleveland is asserting that twofold. Number one, that he had a defense to the crime by being insane at the time it was committed. And number two, not being of sound mind when he took the plea to understand what was occurring and that the plea would require that he be found guilty and then be sentenced pursuant to any sentence agreement by Your Honor. It is supported by the affidavit. And I would also just refer Your Honor to the documented diagnoses in the PSAR regarding his mental capacity. Thank you, Judge.
Thank you. Response?
Thank you, Your Honor. As this court knows, for a defendant to withdraw their plea, they have to demonstrate a defect in the plea taking process. And a defendant raising a claim of ineffective assistance has the burden to show that counsel's performance fell below an objective standard of reasonableness, and that but for that deficient performance, there's a reasonable probability the outcome would have been different. And in this case, I want to talk about them separately, because first, in the matter of competency, there's no evidence in the record here to show that the defendant was not competent to take a plea. In the record, to the contrary, there are significant examples. The defendant understood the proceedings against him and was assisting his defense in a rational manner. He had a bond hearing before this court, where the defendant explained in detail. He understood his bond conditions, what a GPS tether was, and what would happen if he didn't follow the court's orders. He had a pretrial before this court, where he said, I was not receiving my medications in the jail. And this court said, okay, let's make sure you get them, and immediately remedied that. Then at his plea hearing, this court specifically explored his mental health with him directly and his attorney, who both said he understood what was going on, and the defendant said, this is a good day. And then he also asked clarifying questions, like about his plea, like whether the victim would be present at sentencing, whether his sentences would be served consecutively, and how long he'd be in the sex offender registry. Those are more intelligent questions, Your Honor, than almost every defendant that we've seen coming before to have a plea. So the record clearly shows competency, which is a base threshold for being able to assist in your own defense at trial. And that is when it comes to a defense of insanity, the record also doesn't demonstrate that the counsel failed to adequately investigate that. Because the statute is clear that mental illness or intellectual disability does not mean we have a defense of legal insanity. The Supreme Court has explained a person can be mentally ill without being legally insane. And I don't deny that there were mentions of different diagnoses that he has had, but in terms of presenting legal insanity, mental abnormalities short of legal insanity are not going to be enough. And trial counsel could have well concluded from all the evidence and the record that the defendant Cleveland would not have been able to meet this standard. The PSAR notes he said,
Sir, if you interrupt counsel, I'm gonna give you 93 days contempt. And we are going to set this out in 93 days. It is not appropriate for you to object. You have an attorney. If you have something to say, I'll address you after all of this. Okay? The people
Yes, ma'am.
have to be respected just as your attorney has to be respected. So I suggest you do not interrupt again. Very clear?
Yes, ma'am. My apologies. Proceed.
Thank you, counsel. Apology for that. You may proceed.
Thank you, Your Honor. And so where I was getting at here, for legal insanity, the defendant would have to show he was suffering from a mental illness or he lacked substantial capacity, either to appreciate the nature and quality or the wrongfulness of his conduct or to conform his conduct to the requirements of law. And so in the PSIR, they do mention that he had mental illness. We agree that that is true. But if we look at the record in this case, in the PSIR and at sentencing, the defendant gave multiple statements of factual recitation of what he believed occurred in this case, or his side of the story. Although he pled no contest, he specifically told the PSIR agent exactly what had happened, that the victim had cheated on him, which enraged him, and so he physically assaulted her. He claimed, although he was convicted of criminal sexual conduct in the 3rd degree, that when that they had sex that day, but that it was merely consensual. And in the police report, the factual basis for the plea that this court used, the defendant had said to the victim, you wanted sex, right? That's what you wanted. Why are you telling me to stop now? those two things coincide, that he had learned the victim had cheated on him and then he sexually assaulted her. What I'm trying to say, Your Honor, is that when he gives a factual recitation of everything that he remembers, he is demonstrating that although he may have had a mental illness, there's no misunderstanding as to what the requirements are under the law, and that he could appreciate the nature and quality of his wrongfulness, because he admitted to the court that he did it, that he did the physical assault. So he's recalling everything that happened. And so to assert a claim of his affidavit is just bare bones that says I was legally insane at the time, but that is not sufficient, Your Honor. The court could have looked at everything in this case, excuse me, the defense attorney could have easily looked at everything in this case and determined that was not a viable offense. And again, at sentencing, the defendant expressed remorse for the physical altercation, that he wanted to be a good father and to atone for the sins that he committed. And again, he told what he quotes says his side of the story. Looking at all of that and his ability to express remorse for what he had done and atone for his sins all shows that he was not and never mentioned in the PSIR to the agent, in the police reports, at the plea, or at sentencing, that at the time he committed these crimes, he was suffering from a mental illness, or that he was unable to appreciate the nature and quality or the wrongfulness of his conduct, or conform it to the requirements of the law. And I just want to point out that he did speak up when he wasn't getting his medications at the jail when he needed them. So it wasn't as if this was something that we didn't know about. This court had a long conversation with him in regards to his other case for aggravated indecent exposure, about medications that are out there for impulse control, etc. But when it came to this case, none of the mental illnesses or any sort of lack of ability to conform his behavior was mentioned, from the factual basis in the police report to the PSIR or to the sentencing, when the defendant showed that he had plenty of opportunities to explain that or talk about it, or for his counsel to explore it if he really did believe that it was there. So we would ask this court to deny the motion.
Thank you. Counsel response?
Just a quick response, Your Honor. I'll just state for the record that Your Honor did properly follow the court rules during the plea taking. However, sometimes defendants just answer the questions because they are told by their attorney to do so. In this case, Mr. Cleveland felt that after that he had this defense that was not asserted and argued and explored before the plea, and we would ask Your Honor for a chance to establish that in the Ginter hearing as well in the alternative. Thank you, Judge.
Thank you. The problem here, and I make an extended record, especially when I am concerned about whether or not someone's competent and should be on medication. And I did, and it's on page 5 of the transcript that I believe you both have. I asked him, have you taken medication yesterday or today? No. Are you supposed to be on medication you're not taking? No, they ran out of my medicine actually. Okay, they're supposed to be getting some more. Okay, does that medication help you think better? Yes. How long have you been off of it? It's been, what, a week now? Okay, so being off it a week, are you able to understand everything? Would you like to delay this until you get back on your medicine, or do you think you understand everything and it's a good day for you? This is a good day. Okay, Mr. Feigelson, I know you always talk to your clients for pleas, sentencings, what have you. Do you believe he's oriented to date, time, and place and does understand, or should we? And Mr. Feigelson says, I believe he is oriented to date and time. He understands what's going on. And I said, I do as well. He was able to advocate for himself, answer all questions from the court, and he's got good eye contact and body language. And I said during this, so if you change your mind, let me know. And he said, yes, ma'am. And I have multiple statements in here that he was able to engage with me, with his lawyer, and advocate for himself. He asked clarifying questions, such as how long will I be on the registry? That takes a lot of brain power and understanding to assert questions that are very specific to the charges. So it's very clear he understood he'd be on the registry. He understood what the charges were. He understood what the sentencing and the conversation was. And he was able I think throughout, to ask questions. In fact, said, yes, I do have a question, though, is the mother of my child, the victim, going to be like involved with this, how the sentencing happens? And I said, yes. He said, okay. And we had a whole conversation about that, so I failed to see how he did not understand what was going on, how he was possibly disoriented. We made quite an extensive record. So, sir, I said I'd turn to you. Is there something you would like to add?
It's a couple things that I would like to add. First one.
But sir, wait, stop. You need to be a lot slower. Zoom does not pick up things as nice as we would like, and I have a court reporter, and it's important we make this record. So I need you to talk like you're reading to a 5-year-old and enunciate, because we have not just the problem of people speaking too fast, but also the Zoom issue. Sometimes there's a delay. So can you do that for me?
Yes, Your Honor.
Okay, now you may proceed slowly.
So the first thing that I would like to bring to the court's attention is that wasn't brought forth through my appeal attorney is the fact that I was scored wrongly on my offensive variables. That was brought up when I got sentenced. That is my A prefix. It's in black and white that was wrongly done. That's irrefutable evidence that I should have at least a chance to be accepted for an appeal. Was that heard?
Anything else?
Other things that I would like to bring to the court's attention, I'm sorry, I gotta slow down. Other things that I would like to bring to the court's attention is I honestly feel as though the prosecution is afraid to give me an opportunity to go to trial, because I took the killer group cap to 4 to 8 and was sentenced consecutively instead of concurrently. While I've been incarcerated in MDOC, Time Computation Unit has contacted me not once, not twice, not 3 times, but 4 times in my 2 years of being incarcerated in prison. I have the legal paperwork I can always give to Tracy Gittleman to get to you guys as evidence. I was wrongly sentenced, and I now want to take back the plea that I entered into because I was wrong, truthfully.
Counsel?
Your Honor, based on what he is saying, all I'm hearing is what we call buyer's remorse, which is not a basis to withdraw your plea and go back. And he wishes he would have gone to trial, or that he, now has a consecutive sentence, which this court did impose, because I believe the reason was for violating his bond, or the conditions of between plea and sentence. And that is exactly, this court sees this all the time, not a basis, especially on appeal, to withdraw your plea. It's buyer's remorse, and that's what he is saying. And I know Ms. Gittleman's probably going to say, he shouldn't be talking anyway, she's representing him, so I'm not gonna hold that, but just to say, that is what we're hearing right now.
As to the OVs, I understand that's his opinion, but it looks like there's no correction needed, or if there was, it was already done, and consecutive was done because of a violation, so.
Well, Your Honor, I would just say that the OV8 he's speaking of has already been objected to and preserved for appeal. And I have explained that we need to first argue the motion to withdraw first, and then we take everything up on appeal, because we had to do this, otherwise it would have been waived. And then as far as consecutive sentence, that is also preserved for appeal already. So yes, I will be appealing those, but those weren't part of this motion because they've already been properly preserved by this court. I don't need to revisit those. Those are ready to go, but I had to do the motion to withdraw first.
Okay.
Yeah.
Great.
May I add another thing, please?
Sir, I think your attorney does not wish you to speak, but if you want to speak, it's against counsel's advice.
Another thing that I would like to explain and elaborate upon, because it takes a special person to expound on it, is the fact that twice it's on the record that I told you, Judge Aquilina, that the county of Ingham County was not giving me my medication. But they might not understand as the prosecution, I don't know her name, and I'm not being disrespectful, but she might not understand due to her not being mentally ill is moments of clarity with a mental ill person comes and go. It doesn't mean the TV mental illness you see with people in straight jackets going crazy, bashing their head off of walls. No, but moments of clarity come and go. There are times where I can function and think clearly. So I want to understand. I want the court to understand. Hey, I can think straight for a good 10 minutes during the court session. That's not hard, but it is different situations that I'm put into that has me thinking in a different way. You know, she might not understand that, and I don't expect her to because she probably isn't mentally ill. It's on the record that twice I said, hey, I don't have my medication. It's documented that I'm heavily mentally ill. This is not an excuse, but it is a very large, great reason that needs to be, looked upon and really looked upon with favor. I'm not saying that for pity. I'm saying it because it's legitimate reasons behind it. It is no excuse. It's a reason.
All right, so, sir, your attorney's already explained that there are some issues that are preserved that are not before this court that are going to the Court of Appeals, which is absolutely fine with me. In regard to competency going up and down in medication, I understand that. You and I went through the record. If I would have thought, or through that issue, and if I would have thought in any way, shape, or form, as I did today with a couple of people, I don't know if you were watching, but I do this regularly, and when I think somebody needs to be assessed for criminal responsibility or competence, I immediately send them and I will not proceed. In your case, and I did read in the pre-sentence investigation report, under the mental health narrative, it reads, Mr. Cleveland reported that he was diagnosed at the age of 11 with attention deficit disorder, schizophrenia, depression, bipolar disorder, and post-traumatic stress disorder. He is currently taking psychotropic medications at the Ingham County Jail, but does not know which medications. When you and I talked about that, you said you've been off them for about a week and you were feeling fine. And I don't know why the jail allowed that to happen, but I did inquire, and throughout, at any point, I would have had what you are asserting now is sort of, you have a good 10 minutes and then you're not on your game, and then it kind of goes back and forth. If I would have seen or thought that, I certainly would have stopped this, but you and I engaged throughout, and the record is very clear. You engaged with this court and your attorney throughout the sentencing, which indicated to me that not only was it a good day, but you were confident for the purposes of sentencing. I do agree that this is buyer's remorse. I don't know why there was not competence or responsibility filed in this case, but I suspect it's because you were medicated, and because of that, you were able to assist counsel and you understood what was going on through this case, or through the incident that occurred that brought us to this case. So I have to look for certain things for you to withdraw the plea, and I do find that there is no defect, that you did not lack substantial capacity, that you clearly knew what was occurring, and were able to assist not only your attorney, but the court in making a good record and answering your questions and showing that you were confident that it was a valid plea, that you understood at sentencing what was going to happen and what was not going to happen, not just then, but even in the future. And that is throughout the sentencing. It wasn't just a one and done. This sentencing took quite a while, as I recall, and we engaged throughout the whole thing, and you were able to have your say. So I am not finding that there was ineffective assistance. I do find that you were competent during the plea, and that you made this decision with your attorney. I also asked you all about that. And there's nothing here that would lead me to believe that I should withdraw the plea, even as to a Ginter hearing. I don't I leave it in the capable hands of the appellate courts. In the event they think that we should backpedal this, I'm happy to comply. I simply do not see it. If I did, I would absolutely withdraw this and we'd go and get you those evaluations, make sure you're on medication, do all of the things that should have probably occurred. But there's no indicators it should occur. So I see a lot of people who are mentally ill, but you did not appear that way at all. You were on top of your game. So I saw no red flags then. I don't see any red flags now. The motion is denied for the reasons I've stated, and I'm adopting the people's arguments as my own. Anything else for the record?
Nothing from the people, thank you. No, Judge, thank you.
Thank you. Good luck to you, sir. Thank you.
I got one thing for record. I said on record that I didn't want him for my trial. You recommended, hey, you wanna keep him from next week, Wednesday? I remember it was a Wednesday. I said, hey, I don't want him as my attorney going to trial. You understood that. I told you that it was incidents going on with them not allowing me to get a new attorney. You remember that,
Sir,
Aquilina, because it's black and white.
I never
I
force
requested
anybody to
one
have.
attorney.
All right, I never force anybody to keep an attorney. If you would have been happy and didn't want to proceed, I would have gotten you a new attorney. That didn't happen, so, again, I have to abide by what my parent judges say, the Court of Appeals and Supreme Court. I leave your case in their capable hands. That is all for the record, thank you.
Yeah, I talked about attorney.
May I present a motion?
You may.
And Ms. Allen has reviewed it. Thank you.
Thank you. I think he wants to talk to you. We can put you in the breakout room, or you can talk to him at a later time.
I can set up a visit with you in a couple weeks. It takes a couple weeks for me to make sure that MDOC can comply. Is that okay, Mr. Cleveland?
Oh, he's muted again.
Well, we have time to talk.
I can.
Well,
Yeah,
we don't-
because everyone's at 3 with victims
Okay.
coming, so I don't want to go early.
I can, but I don't know where do I do it?
If you have a computer, you can just go into
Oh,
the,
I can do it on my phone, maybe.
yeah, you can just go into one of the,
Okay, and then
the
sign in. Do I need to Zoom here though?
yeah, you,
Okay.
So we'll make you copies of this, and then, so we're gonna put you in a breakout room. We'll have to unmute you, so you can talk to your attorney.
Thank you, Judge.
Thank you. Appreciate the time you all put in this.
Thanks, Judge.
20007 assigned.
You have to unmute it now.
Oh, there were two that were 620. There were two that were the exact same.
So where's the other,
Yeah.
what else do we have?
We can do that civil matter real quick, it'll be a quick one.
Where's?
What is it? What time?
1 o'clock, page 6, second one down, PHH mortgage versus Christmas. Want to cancel it?
Cancel what?
Christmas.
And are they here?
Yeah, they're at least one person on Zoom.
All right, this is docket 253483CH PHH Mortgage Corporation successor by merger to Ocean Loan Servicing LLC versus David Christmas, Kelly A. Christmas, and United States of America on behalf of the Secretary of Housing and Urban Development. Counsel, your appearances for the record.
Good afternoon, Your Honor. Excuse me. Michelle Clark appearing on behalf of plaintiff.
And there is no one here on behalf of defendant. This was properly noticed, and the court and counsel has certainly waited a sufficient time. I believe this was scheduled for what? 2 o'clock, 1 o'clock? 1 o'clock. So we've waited an hour and 38 minutes. So no one's come to plead or otherwise defend. So, counsel, did you need to make a further record, or do you have an order to present? This is an order, you have to sign the order confirming staff.
Yes, Your Honor, you entered a judgment back in October for foreclosure, requiring that I jump through some hoops for the sale. And this motion is demonstrating and attaching documentation to say, yes, I did publish, yes, I did post, yes, the sheriff did sell it. The only unusual thing about this motion is that there is a deficiency judgment. At the bottom of my motion, I gave you the math. It's over $12,000. And I did attach a proposed order. So I'm just seeking confirmation of a sale, having done everything you asked.
All right, court is in receipt of the order confirming sale, granting money judgment and release of Liz Pendens. Court has signed it and it is ready for entry with the clerks. We'll get copies out and you have presented a self-addressed envelope, which court appreciates, and we'll get that to you and get copies out to everybody. Is there anything else we can do for you?
No, thank you, Your Honor.
All right, and I did review the amounts and they do comport with what you said on the record and what you pledged. So this would close all matters and we'll get this filed.
Thank you. Thank you. Have a good afternoon.
You too, that is all for the record.
We'll keep it quick.
What do we now?
I think Kristen Cowgill next.
Is this the last one?
No.
No,
Okay, on the weapons court, so hopefully.
the other one is set at 3.
Is there like one more after that?
Janelle Robbins is set.
Yeah.
And mine is set for 3 too, Trina.
You have one at set at 3?
We have two sets.
Yeah. Why are we setting anything at 3 with weapons court?
Do we
Because
have
the
weapons
Clayton
court
County-
for sure?
We have weapons court? I think
Yes.
So,
Oh, okay, because I didn't get a schedule, weapons court schedule, so I didn't know.
I don't know if I don't want to add it.
okay, so I'm sorry, which one we just did?
Bringing Kristen Cowgill. It was set for 8:30.
Geez, why are we doing it so late?
Sorry, 9.
But still.
Okay. Any countdown?
I don't see where I put it. I had it up here. Nope, that's not it. I had it up here.
No, I have no files.
Oh, I got
No.
it. Oh, it's my good one.
So what are we doing on this Cowgill?
Bench warrant.
Okay, this is docket 24-1032 People of the State of Michigan versus Kristen Cowgill. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of people of the state of Michigan.
Miss Kristen Cowgill.
All right, and where's your client?
You know, I really don't know. I replaced Assistant Public Defender Jackson on the case. I have not heard from her. I had sent her an email with having made a mistake on the time. I told her 1:30 instead of 9 o'clock, and
Okay.
so.
Well, we do have the 9 o'clock, we have the 1:30, and it's now 2:43. She's failed to appear regardless, so bench warrant bond forfeiture. If you can get her here, bring her in, otherwise, this is gonna be issued immediately, so this is the final pretrial. She had ample notice one way or the other, we would have given that to her, so. She's not in the courtroom or hallway, there's no phone calls. I think my staff was on the alert up to 2 different times, we've been looking for her, and she's failed to appear, so. That's how we'll proceed, thank you.
You're welcome.
Next matter.
The only other one.
What about Mullins? What was happening with that?
There was a pretrial on that, Your Honor, as the defense plans on filing a motion to quash.
Okay.
Is it Yang's?
Yeah,
He's on Zoom.
okay, we're just waiting on Mr.
Are
Robbins.
you here in another one?
Yes, I'm here in Travion Green,
3 o'clock.
but we had the victims, and we had victims who were planning on appearing, so. I don't know.
This is docket 25-1611 FH, people of the state of Michigan versus Janelle Robbins.
It's also set for 3, Judge.
Oh, this is set for
And
3
she's
too?
coming
We're waiting for
from,
the Clinton County
Clinton
to
County.
bring Mrs. Robbins in.
So we're done until 3?
Yes.
Okay, let me know if we can go early at all, because I've got weapons court, I don't know why anything's set at 3.
Unfortunately, Clinton County only does rates at 3, or Eaton County, I believe, actually, is Eaton. Fortunately, the only time we could set this.
So wait a minute, they only do writs at 3, is that every day of the week?
Yes,
So in the future, we'll just do it on a Thursday or a Tuesday,
understood, Your Honor.
or Monday, whatever. If I'm in trial, what we can do is just take a break then and do whatever it is, or just end early for the day, because I can't hold weapons court, or we can do it on a date, I don't have weapons court, we can't hold it at every house. Okay, so we stand in recess.
next file.
Yeah. Thanks for getting my minutes. I told God at my house. Okay, I get it. You got it, man. So we can go to the second. It didn't look good. Oh,
That's what they all say.
I didn't look at it.
Not sure which one.
I don't know. It's the way.
It's the way.
And there's Ms. Robin, so we are ready on everything. There's green.
Okay, this was docket, or is docket 24440 FC, people of the state of Michigan versus Travion Deshawn Green. Counsel, your appearance for the record.
Elizabeth Allen on behalf of the people, Your Honor. Good afternoon, Your Honor. Tracy Gittleman for Mr. Green.
All right, is this Mr. Green on Zoom here?
I believe so, Judge.
All right.
Which one?
I believe it's the top.
Sir, are you Mr. Green in the blue shirt?
They're both.
Or both blue shirt? Okay. Okay, both in blue. Okay, Mr. Green, can you raise your right hand? Okay, it's right there. All right. And we need to unmute you, sir. Is there someone there who can assist you in unmuting you? All right, looks like you're unmuted now. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
Oh, ma'am.
Are you supposed to be on medication you're not on?
Yeah.
Are you-
Yes, ma'am.
Is that anything that would help you think more clearly?
No.
Any sign of fever, COVID, or other illness?
No.
And you had no time to speak with your court-appointed appellate attorney, is that correct?
Yes, ma'am.
All right, thank you. And this is defendant's motion to withdraw the plea and or for further hearing and to correct the pre-sentence investigation report.
Thank you,
Counsel,
Judge.
you may proceed.
I've already spoken to Ms. Allen, and we are in agreement on correcting the pre-sentence report, so that's all set.
Okay.
As far as withdrawing the plea, Your Honor, I'm sure Your Honor's familiar with this case, the facts of the case. I know there was a lot of colloquy during the sentencing transcripts and the plea taking regarding the issues here. But this was a case where my client pled to discharge of a weapon from a vehicle causing death. And the issue that arose during the sentencing, there were two sentencings in one day, one in the morning and one in the afternoon, was whether there were some text messages that existed or didn't exist, whether they were exculpatory or not. There was some discussion with Mr. Green's attorney on the record, with Your Honor as well, with regard to whether self-defense was a defense. Your Honor had questioned Mr. Green on the fact that, did he see the gun or didn't he see the gun? After discussing with Mr. Green, he does request to withdraw his plea and or for a Ginther hearing based on this, which is a signed duly notarized affidavit as an offer of proof that his attorney did not assert the defense of self-defense, that he wanted to assert that defense, that he was under the impression, one of the reasons he did not, that he took the plea was because he was under the impression that text messages existed when he found out after the fact that they actually did not exist. Had he known that these text messages did not exist, he avers that he would have went to trial and not pled, and that those would have been exculpatory to his innocence. Mr. Green claims that he acted in self-defense. that he saw a gun and was afraid of being shot at, and then he shot, that he was defending himself. He was in immediate danger of being shot. And because his attorney did not inform him timely that the text messages did not exist, in other words, didn't tell him before the plea, but did tell him after the plea, and he wanted to go to trial, and had he known that these text messages did not exist, he would have asserted his right to trial. He feels that he was coerced to plea based on thinking these text messages existed when they did not exist. Further, Your Honor, he does, as asserted during the 2 sentence hearings, that he was acting in self-defense. Self-defense is a defense to the crime. If he felt he was in immediate danger of being shot at and he was defending himself, or at least goes to the question of whether there is guilt or innocence for a trial. I would just rely on the remainder of my brief and the colloquy between the court and Mr. Green, that we would either request to withdraw plea or a Ginther hearing to explore further, Your Honor. But we assert that the affidavit and the colloquy establishes, at the very least, a need for a Ginther hearing or to withdraw plea. Thank you.
Well, I had, as you said, extensive conversation with them, and I'll let the people speak, but I just was refreshing my own memory because I remember not every detail, I do so much, but I said, what would be important is, did you see the gun was pointed at you? Did you believe he was going to shoot it? Is that a reasonable belief? And defendant said, if I'm being honest, I didn't see him pointed at me. I mean, that's a problem. Wouldn't you agree?
I agree, but he is asserting that some text messages that he thought existed did not exist, and he feels that the fact that they did not exist is exculpatory, as an extra fact to put into the ring here.
Does that make this more or less likely? I mean, I guess I don't see how the text messages in the heat of the moment make him decide to pull the trigger or not.
From what I understand, he thought there's some text messages that did exist before the plea that whether what they said, I don't know what they said or could have said.
Counsel, he doesn't know the law, but you do. How does that raise a defense? Text messages in that moment, he has to believe that he was in imminent danger. And how does a text message harm any of us?
I can't say, I wasn't there. I can just say that he is asserting that had he known that there were no text messages, he was informed that there were. And perhaps he was afraid of what they would say. I don't know.
Sir, here's the deal. If you want to interrupt, I'm going to have this in 93 days. I will let you speak at the appropriate time, but if you want to interrupt, we will resume this in 93 days. Do you understand? That's contempt. We will not be rude or interfere. Do we understand?
Yes, ma'am.
Thank you. Thank you, counsel.
Your Honor, may I, if he wants to explain about the text messages, I don't have a problem with that, or can I meet with him in the breakout room for a minute?
You can always meet with him in the breakout room for a minute if you'd like to do that. And if you want to do that, let me hear from the people first before you do that.
The content of the text messages is in the record, and I can talk about that if we can, please.
Okay. And then I can put you in the breakout room. You may proceed.
All right, unless you're done.
Yeah, Your Honor, I would be done right now. Thank
Thank
you.
you.
Your Honor, first, obviously, the whole claim here is he's trying to withdraw his plea with a claim of ineffective assistance of counsel. And his claim is that counsel did not tell him that these text messages that he believed existed had been deleted before he entered his plea. First of all, trial counsel said on the record that he did tell the defendant that these text messages did not exist before he took his plea. And trial counsel said he believed that to be cleared up. And second of all, trial counsel and the prosecutor both said the text messages that had been deleted were from who they believe was the intended victim, a guy named George. And they were allegedly messages that this defendant and the victim had sent him that were aggressive and threatening. So they were not exculpatory. They were messages that if they had gone to trial and had existed as the intended victim had described them to the police, would have shown that this clearly, in addition to the video and the other evidence, was not in self-defense. So number one,
So let me just,
yep,
so without those, I think he's saying, well, if I wouldn't know they didn't exist, I go forward, but even without those, there's still enough evidence to take to the jury. Not gonna change the outcome.
beyond, Your Honor, and that's what I want to also say, because we are in a unique circumstance here where trial counsel already explained on the record at length how and why he advised defendant to do what he did. Because typically, if you want to have a Ginther hearing to have a trial counsel explain it, that would be possible. Here, trial counsel said to this court, number one, that he recommended that defendant take this plea because the prosecutor said if this went to trial, she was going to amend the charges to open murder, which she is legally allowed to do. And trial counsel said the very likely outcome based on the videos and the evidence is that defendant could be convicted. And so trial counsel recommended this plea, first of all, based on that. And second of all, trial counsel said we investigated self-defense at length, that he and his team dissected the video and the evidence. And the video showed, per his lawyer, Your Honor, this was all in the record. His lawyer said the video showed defendant and the victim armed with guns and beginning to shoot before the person they were shooting at could have done anything. Counsel said the video did not show that the intended victim had pulled a gun or that he pointed an object at anyone, and that the video showed defendant could not have possibly seen that the intended victim even maybe had a gun or could have pulled one because of where they were located. And as this court noted, defendant even conceded that at sentencing, if I'm being honest, I didn't see him point it at me. And so it was not ineffective assistance to advise him, self-defense is not viable. You have a plea offer here that is going to, otherwise you're facing life without parole for first-degree murder. And then also, as trial counsel and the prosecutor said, these text messages only would have increased the prosecutor's ability to convict this defendant because they showed his intent to go in there and be aggressive and threaten their intended victim. But the lack of their existence, which trial counsel said he told him before the plea was entered, would not have made a difference. And so we would ask you to deny this motion. I think, as I said before, sometimes we end up in the situation because I think there's a buyer's remorse where he regrets that plea and perhaps wishes he would have gone to trial or perhaps could have gotten something else. But that is not a basis to withdraw the plea, and there's no evidence of ineffective assistance of counsel.
I would agree that. I'm certainly happy to listen to what defendant has to say, but there was a Cobb's. I do a Cobb's every blue moon. Now, I don't even do it, I think I do one a year. And this because there was really a settlement, an agreement that included the decedent's father. This was just a tragedy all the way around. This was really the deal of a lifetime. It was, I think, 10 to 15 years, and he was facing life. So, and I do recall the people saying, well, if you don't want to take this, I can do this, that, or the other thing. And everybody was opposed to that. And so I did the 10 to 15 years with credit for 417 days. I am certain that defendant at his youthful age feels like this is an eternity. But life without parole or a real life sentence will really impact him even worse. If we go to the people don't have to make another offer if I withdraw this. I don't think it's in his best interest, nor do I think that there was any defect in the plea. I think it's a valid plea, and the outcome's not going to change. There's ample evidence here regardless, but I'm happy to make a further record for appellate purposes, counsel.
And for the record, Your Honor, I did advise Mr. Green of the risks involved with withdrawing the plea and the possibility of life without parole. And obviously, I would never have filed this motion without discussing that. And Mr. Green did assert and duly sent in a notarized affidavit that I sent in for him. So he has been advised of the risks. I would only ask Your Honor possibly to break out room real quickly, Your Honor, being so compliant, just to make sure I cover everything.
All right, so we're gonna put you in a quick breakout room before you address the court.
Thank you, Judge.
We're off the record on this, and when you're ready, so we can resume and conclude. Is there anything else we're doing today?
No logins, Your Honor.
You should have that one already. They had the police sheet and everything as well.
All right, this is, yeah. are we doing this? What is this? This is gonna be okay?
So it's a bench warrant arraignment, Your Honor, however, I have worked out a plea agreement.
Okay, we're gonna. John, did you make that?
Yeah, I hand you.
Okay. All right, this is docket 251611 FH, People of the State of Michigan versus Janelle Robbins. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Joseph Yang, on behalf of Ms. Robbins. I'm joining via Zoom. She's joining us via Polycom from the Eaton County Jail.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Yes. You may put your hand down. Have you taken any medication yesterday or today? What? Have you taken any medication yesterday or today? No. Are you supposed to be on medication you're not on? No. Any sign of fever, COVID, or other illness? No. You had enough time to speak with Mr. Yang? Yes. When you're not in lockup, is your home located on Holt Road? You said what? When you are not in lockup, is your home located on Holt Road? Yeah. Okay. Are you a US citizen? Are you never mind. Are you a US citizen? Ma'am, are you a US citizen? Are you a US citizen?
Yes, I'm sorry, I can barely hear you on this tablet.
Yeah, I'm sort of shouting here, I don't know what's going on there, they probably need to turn the volume up. There's going to be a plea today. Were you on probation, parole, or bond conditions at the time of the offenses you're pleading to?
No.
Okay. What is the plea agreement?
Yes, Your Honor. Ms. Robbins will be pleading to count 2, possession of methamphetamine, and added count 3, home invasion 3rd degree. Upon successful plea and sentencing, count 1 will be dismissed. There is also an agreement to no upfront jail at the time of sentencing, so long as the defendant agrees to inpatient treatment as part of their probation. There is also an agreed upon restitution amount of $175 to the victim's family. That's in regards to damages done to the home.
Is that full, fair, accurate, and complete? Counsel?
Your Honor, I believe there's one more that a case under review would not be issued.
Is there a case under review?
Oh, that is correct, Your Honor. I apologize. The people would also agree not to prosecute Michigan State University Police Department report number 2658100852.
Thank you. Now, is it full, fair, accurate, and complete?
It is, Your Honor.
Ma'am, is that full, fair, accurate, and complete, the agreement? Did you hear it?
Yes.
Okay. And counsel, you're waiving reading of the MSU report 2658100852 as well as count 1, home invasion 2nd.
Yes, Your Honor.
As to count 2 and count 3.
Yes, Your Honor. People of the state of Michigan versus Janelle Leah Robbins. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 2, controlled substance, possession of methamphetamine/ecstasy, on or about November 23rd, 2024, at 915 North Washington Avenue, Lansing, Michigan, 48906, Ingham County, State of Michigan, the defendant did knowingly or intentionally possess cocaine or methamphetamine, contrary to statute. That is a felony that is punishable up to a maximum of 10 years and or $15,000. And added count 3, home invasion in the 3rd degree. On or about November 23rd, 2024, at 915 North Washington Avenue, Lansing, Michigan, 48906, Ingham County, State of Michigan, the defendant did break and enter, or did enter without permission, a dwelling located at 915 North Washington, and while entering, present, or exiting the dwelling, did commit a larceny, a misdemeanor, contrary to statute. That is a felony, punishable up to a maximum of 5 years and/or $2,000. Court shall order law enforcement to collect DNA identification profile sample for sentencing or disposition, if not taken time to rest, and against the peace and dignity of the state of Michigan.
Thank you. Ma'am, did you understand what was just read?
Yes.
So you understand count 2, possession of a controlled substance known as methamphetamine is a felony punishable by 10 years. And count 3, home invasion third is a felony punishable by 5 years, and you must pay restitution, and it appears there's $175 is being requested. Do you understand all of that?
Yes.
And did you agree to the $175?
Yes.
Okay. And it looks like you went over the advice and rights form with your attorney, but you have not signed it. Is that correct? Because you're incarcerated?
Yes.
All right. And counsel, would you like me to read that to her, or just note that it was read to her by counsel?
Your Honor, I think that a acknowledgement on the record that we have reviewed the advice of rights should be sufficient.
So ma'am, do you have any questions about your rights?
Yes.
Do you have questions about them or no?
I've reviewed them.
And do you have any questions? Do you have any
Oh,
questions
no,
about
no, I
your
don't.
rights?
I'm sorry. I'm sorry.
So you've gone over them with your attorney and you understand your rights?
Yes.
Yeah. Okay. And all right, ma'am, you've decided to take a plea of your own free will?
Yes.
And no one forced, threatened, or coerced you to plead, is that correct?
That's correct.
And you decided to plead after you consulted with your attorney?
Yes.
And you've been satisfied with the representation of your attorney?
Yes.
As to count 2, possession of a controlled substance known as methamphetamine, how do you plead?
Guilty.
As to home invasion, 3rd degree, count 3, how do you plead?
Guilty.
And there's a recommendation for no upfront jail as long as you go to treatment and complete that. That would include any aftercare. If you violate the law or you don't go to treatment, then I could send you to jail or prison. Do you understand that?
Yes.
All right. And has anyone told you what I will do at sentencing other than that as part of the plea agreement?
I'm sorry?
Has anyone promised you what I will do at sentencing?
No.
Because I don't know. I will make up my mind at sentencing. Do you understand that?
Yes.
All right. Did these offenses occur on or about November 23rd, 2024?
Yes.
In the city of Lansing, county of Bingham, state of Michigan?
Yes.
At a specific location known as 915 North Washington Avenue?
Yes.
You were in possession of methamphetamine?
Yes.
And you understood that it was not lawful for you to use or possess it?
Yes.
And you didn't have a prescription for it?
Correct.
And when you came in contact with law enforcement, where did they find the methamphetamine?
Where did they find it?
Yes. On your what?
On my person.
Where on your person?
In a syringe.
On your what?
In a syringe.
Where was that syringe hidden on your body?
It was in a bag.
Was it a bag, a purse, or a backpack or something?
Yeah.
And that was in close contact to you?
Yes.
And you owned that?
Yes.
And you would agree it was under your control?
Yes.
And did you break and enter a home?
Yes.
And you did not have any right, entitlement, ownership, or permission to enter that home, is that correct?
Correct.
And that home was located at 915 North Washington Avenue?
Correct.
And you would agree that people lived there?
Correct.
And how did you enter the home?
Through a window.
And did you have to push the window open?
Yes.
And you went in there with the intention to take things or commit a larceny that did not, of things that did not belong to you, is that correct?
Correct.
And did you in fact take something that didn't belong to you?
Yes.
What was that?
Credit cards.
All right, and were those eventually returned?
Was it? Yes.
Okay. And you broke that window, and that's why the $175 in restitution is being requested. Would you agree with that?
Yes.
Okay. On behalf of the people, any additional questions?
No, Your Honor,
On
thank you.
behalf of your client, Mr. Yang, any additional questions?
The defense is satisfied, Your Honor.
Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Has court complied with the court rule?
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, stress, coercion, or promises of leniency. I also find there is sufficient grounds to accept defendant's plea. Therefore, count 2 and count 3 on the amended information will enter. Count 1 is hereby dismissed. Any contraband, if any, and it sounds like there was at least illegal drugs and paraphernalia. Any contraband, drugs, paraphernalia is hereby forfeited. Do we have a sentencing date?
August the 3rd at 11 o'clock. AM.
Does that be with your schedule, counsel?
That does work for me, Your Honor. August 3rd at 11?
Yes.
Yes.
And you'll have to cooperate with probation. They'll come and see you and we'll talk about sentencing at that time. And then how long are you going to be? You're in Clinton County, is that right?
I'm in Eaton County until the 23rd.
The 23rd of what? August or July?
July.
Okay.
Your Honor, if I may.
Yeah.
Thank you, Your Honor. I'd like to request the PR bond be reinstated. So she's under sentence in Eaton County, and then she'll be transferred to Clinton County because she has a pending matter in Clinton County that's just recently bound over to circuit court. That has a 15,000, 10% bond on that. That is for possession of a taser. Those are the allegations. She would prefer to be in Clinton County if she's going to stay incarcerated as opposed to Eaton County, as well as if we can get her a PR bond here, we can work on getting her a bed prior to sentencing, as opposed to coming back if we get a bed available. So I would like to request the PR bond be reinstated in this matter so that we can kind of take care of one file at a time. She has 3 jurisdictions that she's dealing with now.
So is it anticipated that the other counties are also going to put her in treatment, or is it just our county?
So Eaton County is a full sentence. She'll be done with that. She won't have any other treatment for that. The Clinton County, I've been in contact with your attorney out there, is Mr. Rothstein, and he is also kind of on the same path of trying to get her into some type of treatment in lieu of jail. So I don't have that case, but he and I have spoken about going down that path.
On behalf of the people?
People are just concerned that Ms. Robbins is a flight risk, and if that she is let out at all. I understand that she has a bond in the current case. The people are just concerned that she's a flight risk, as this is a bench warrant arraignment, Your Honor. So if she can get treatment, I have no issue with her being sent to treatment, but her just being let out on a PR bond that people are concerned about. And additionally, Your Honor, the case we dismissed was in May, in between when she was a failure to appear, and that was another drug charge. The people are also concerned for her own safety and well-being, and if she is let out, she may go back to controlled substances.
All right, here's what I'm gonna do, ma'am, I am gonna release you on a $50,000 PR bond only. You'll only be released on a $50,000 PRB with a jail PR bond with a jail GPS tether, but it's only upon entry into meth-specific long-term residential treatment. So you're gonna go from jail into treatment.
Yeah.
If you're not going into treatment, you remain in jail. And as part of that, you will sign all necessary releases so we can verify that you're doing what you need to do in treatment. And if you are in jail or in treatment, then we will have this hearing, the sentencing on Zoom, if that's okay with you. Is that okay with you?
Yeah, sorry, yes, yeah.
Okay, counsel, is that okay?
Yes, Your Honor, that
So
works for the
they're
defense.
really, she's not being released, except to treatment. And ma'am, if you don't stay in treatment, I'll put you in prison, so you get treatment there. I don't really care about jail, I do care about your life. If you aren't going to avail yourself of the treatment, if you leave treatment, that tells me a whole other story, that you prefer drugs and death, and I don't want that, so I will put you in prison. You need to understand the severity of the message that you're sending to this court and your community, because probation treatment is a privilege. And if you do not recognize that privilege, then we'll get you treated in prison. They're doing a lot better job now. Do you understand?
I understand.
Any questions, counsel?
Nothing from the defense, Your Honor. Thank you.
All right, ma'am, we're gonna get you a copy of this. You need to cooperate with probation for the pre-sentence investigation report so we can get to sentencing, and then you and your attorney and I will discuss it at sentencing, okay?
All right, thank you.
Thank you. Thank you, good luck. Okay, we're back on the record. Nancy, you tell me when.
Go ahead.
On docket 24440 FC. We need to unmute defendant. And counsel, you had an opportunity to speak with your client,
I did, Your Honor.
and does he wish to address the court?
Yes, I would like to address the court, Your Honor.
Okay.
I am asking for an adjournment, and I know that there's some people that have appeared here, and I apologize to the court. I'm gonna put this on myself, because I think there are some other things that I have to review and brief that I did not see. I believe that Mr. Green he said he sent me an affidavit handwritten by himself, which was about 3 or 4 pages. I don't know that I received that in the mail, but it might have been that I received it. But
is it anything that is really going to sway this court?
It might, Your Honor, and the problem is this: I need to actually review the transcripts against it. And he also says that he has something that he needs to send me, which is a statement from someone named George that I don't have, that he has, that he's gonna send me from his cell. And I need to be able to review all of this and process it, have a meeting with him, and then possibly supplement, and then have any further oral argument. Hopefully that would conclude the matter. But I feel as if I would be ineffective if I do not ask for an adjournment and look into this, Your Honor. So I am respectfully requesting an adjournment. I apologize to the prosecutor and the victims that were.
It's not your fault, I mean, if he doesn't give you the information, and I've got to understand, I have what I think is a very good record here. And this was a global resolution in his favor that no one had to agree to, and that I was hesitant to agree to. This is like the deal of a lifetime. And he says very clearly, if I'm being honest, I didn't see him point the gun at me. So I'm not sure how anything's going to sway me, because it's not what somebody else saw, it's not what somebody else said, it's what he felt in that moment. We look it through his eyes as the law. And he says he didn't see the gun and he fired. The emails are irrelevant. I don't know what relevant thing you can bring to me. Ms. Allen.
I'm in the same boat as the court, but I didn't have to leave it to your discretion, because she's saying she's going to be ineffective to not. But I also would like, I completely agree with what the court has said.
All right, so out of deference to you, counsel, I am going to give you some time to do that, to make a complete record for the Court of Appeals. He's certainly able to appeal this to them, but we might as well make a complete record. I don't think it's gonna go anywhere. I think if it does go anywhere, it will be significantly detrimental to him. I think at his youthful age, this is seeming like 20 lifetimes to him. Because that's how life goes. When you're young, it's every day drags, but when you're old, it's faster and faster and faster. So I get where he's coming from, but it's just not viable. But I'm always willing to listen, so let's make a further record and let's set this out. Let's set this out to November 4th at 11 o'clock.
Thank you, Judge, I really appreciate it.
And I'm doing that, I know, again, it seems like a long time, but there is always a lag time when someone's in prison and you're out and getting to him, and then if he's got this other issues, and I want it to be 100%, I don't wanna come back a third time, because I'm not gonna do that. So, from where I look, he's not going anywhere, and you need time to explore whatever it is he's giving you, rather than claiming, again, surprise, surprise, and asking me to move it. My docket is so congested, I'm just gonna do it then. Ms. Allen, are you good with that date? Are you both good with that date?
Yes, Your Honor.
Okay, so it'll be a continued appeal or motion.
What time was it, Your Honor?
11 o'clock?
11 o'clock. Thank you very much. I greatly appreciate your